Adoption of UN Declaration on Rights of Minority. Introduction. No international legal instrument fully dedicated to the rights of minority groups existed until 1992, when the United Nations Declaration on the Rights of Persons belonging to national or ethnic, religious and linguistic minorities, hereafter UN Declaration on Rights of Minority, entered into force. This is the only United Nations instrument which addresses the special rights of minorities in a separate United Nations document. It offers a richer understanding of minority rights on the individual and collective levels in terms of entitlement. It also contains measures which states could implement to create an environment conducive to the enjoyment of such rights. States are also asked to implement national policies and programs with due regard for the minority interests. The cornerstones of the declaration are the principles of non-discrimination, effective participation, and protection and promotion of identity. Purposes of the declaration. According to the commentary to the UN Declaration on Minority Rights, prepared by the Working Group on Minorities of the Subcommission on the Promotion and Protection of Human Rights, hereafter commentary, which was adopted by UN General Assembly in 2005, the purposes of the declaration is set out in the General Assembly Resolution 47/135, and the preamble to the declaration is to promote more effective implementation of the human rights of persons belonging to minorities, and more generally to contribute to the realization of principles of the Charter of the United Nations, hereafter UN Charter, and of the human rights instruments adopted at the universal or regional level. Thus, the main purpose of the declaration is to advance human rights and the principles of UN Charter. Interpretation of and comments on the title and the individual articles. The declaration consists of 9 articles in addition to the preamble. These are explained below. Explanation of Article 1, Clause 1.1 and 1.2. Article 1.1 defines the relationship between the state and its minorities. The commentary remarks that minority protection by state is based on 4 requirements, such as protection of continued physical existence, as well as protection of religious and cultural heritage, non-exclusion, non-discrimination, and non-assimilation. Article 1.2 states that legislation is needed and it must be complemented by other measures in order to ensure that Article 1 can be effectively implemented. In terms of process, it is essential that state consult the minorities on what would constitute appropriate measures. Any differences in policy must be based on objective and reasonable grounds in order to avoid discrimination. The commentary remarks that other measures include, but are not limited to, judicial, administrative, promotional, and educational measures. Explanation of Article 2. Article 2.1 is on minorities' right to enjoy their own culture, to profess and practice their own religion and to use their own language in private and in public freely and without interference or any form of discrimination. The commentary remarks that words such as freely and without interference or any form of discrimination show that it is not enough for the state to abstain from interference or discrimination. It must also ensure that individuals and organizations of the larger society do not interfere or discriminate. Article 2.2 is on minorities' right to participate effectively in cultural, religious, social, economic, and public life. The commentary remarks included in public life are, among other rights, rights relating to election and to being elected, the holding of public office, and other political and administrative domains. Participation can be ensured in many ways, including the use of minority associations, membership in other associations, and through their free contacts both inside the state and across borders. Article 2.3 is about effective participation in decisions on the national and regional level. The commentary remarks that effective participation requires representation in legislative, administrative, and advisory bodies, and more generally in public life. Persons belonging to minorities are entitled to assemble and to form their associations and political parties, and thereby to aggregate their interests and values to make the greatest possible impact on national and regional decision making. Article 2.4 is about minorities' right to establish and maintain their own associations. The commentary remarks that the right to associate of persons belonging to minorities extends both to national and to international associations. Their right to form or join associations can be limited only by law, which is necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health or morals, or the protection of rights and freedoms. Article 2.5 is on right of the minorities to establish and maintain free and peaceful contacts with other members of their group and with persons belonging to other minorities, as well as contact across frontiers. The commentary remarks that the right to contact has three facets, such as the right to intra-minority contacts, inter-minority contacts, and the right to trans-frontier contacts. Such contacts must be free but also peaceful, and the aims must be in conformity with the Declaration and generally with the purposes and principles of the UN Charter. Explanation of Article 3. Article 3.1 makes it clear that they shall not be subjected to discrimination for manifesting their group identity either from the government or persons belonging to majorities. The commentary observes that the most important aspect of exercising their right is the collective exercise of rights. Article 3.2 makes it clear that persons belonging to minorities shall not be disadvantaged in any way for choosing not to belong to the minority concerned. This provision is directed both towards the state and agencies of the minority group. Explanation of Article 4. While states are generally obliged under international law to ensure that all members of society may exercise their human rights, states must give particular attention to the human rights situation of persons belonging to the minorities because of the special problem they confront. Article 4.2 is on the responsibility of the states to take measures to create favorable conditions to enable minorities to express their characteristics and to develop their culture, language, religion, traditions and customs. The commentary remarks that the first part of the phrase "in violation of national law" raises somewhat more difficult questions. It is clear that the state is not free to adopt whatever prohibitions against minorities' cultural practices that it wants. If that were the case, the Declaration and Article 4.2 in particular would be nearly empty of content. As long as the prohibitions are based on reasonable and objective grounds, they must be respected. Article 4.3 is about the responsibility of states to take appropriate measures so as to provide the minorities adequate opportunities to learn their mother tongue or to have instruction in their mother tongue. The commentary remarks that language is among the most important carriers of group identity. Therefore, states shall encourage the promotion of the linguistic identity of the minority concerned, such as by allowing minorities to learn their mother tongue or to have instruction in their mother tongue. The overall purpose of Article 4.4 is to ensure egalitarian integration based on non-discrimination and respect for each of the cultural, linguistic or religious groups which together form the national society. Article 4.5 calls for the integration of everyone in the overall economic development of society as a whole, while ensuring that this integration takes place in ways which make it possible for persons belonging to minorities to preserve their own identity. Measures taken under Article 2 to ensure participation facilitate this process. Explanation of Article 5. Article 5.1 is about national policies and programs with due regard for the legitimate interests of persons belonging to minorities. The participation of persons belonging to minorities in the economic progress and development of their country, Article 4.5, can be achieved only if their interests are taken into account in the planning and implementation of national policies and programs. Beyond purely economic aspects, policies and programs include educational, health, public nutrition or housing and settlement, etc. Article 5.2 is on programs of cooperation and assistance among states with due regard for the legitimate interests of the minorities. The commentary remarks that development agencies, financial institutions, and the others involved in international cooperation have a dual task to ensure that, number one, legitimate interests of minorities are not negatively affected by the measures implied in the cooperation envisaged. Number two, persons belonging to minorities can benefit as much as members of majorities from that kind of cooperation. The notion of due regard means that proper weight should be given to the interests of the minorities, all factors taken into account. Explanation of Article 6. Article 6 encourages states to cooperate in order to find constructive solutions to situations involving minorities. The commentary remarks that states should observe the principle of non-intervention in their bilateral relations. They should abstain from use of force and also from any encouragement of the use of violence by parties to group conflicts in other states, and should take all necessary measures to prevent incursion by any armed group into other states in order to participate in group conflicts. On the other hand, they should, in their bilateral relations, engage in constructive cooperation to facilitate on a reciprocal basis the protection of equality and promotion of group identities. Explanation of Article 7. Article 7 is about states' cooperation in order to promote respect for the rights set forth in the Minority Rights Declaration. The commentary remarks that the cooperation called for in Article 7 can be undertaken at the regional and sub-regional levels, as well as at the level of the United Nations, such as through the Working Group on Minorities. Explanation of Article 8. Article 8.1 is about the fulfillment of international obligations of states in relation to the minorities. The commentary remarks that the declaration does not replace or modify existing international obligations in favor of persons belonging to minorities. It is an addition to, not a substitution for, commitments already met. Article 8.2 is about the exercise of the rights set forth in the declaration by minorities, but which should not be against the infringement of rights of other people. The commentary remarks that the declaration is intended to strengthen the implementation of human rights in regard to persons belonging to minorities, but not to weaken for anyone the enjoyment of universal human rights. Consequently, the exercise of rights under the declaration must not negatively affect the enjoyment of human rights for persons who do not belong to a minority, nor for persons who belong to the minority. Article 8.3 points out that under normal circumstances, measures to ensure effective participation or to ensure that minorities benefit from economic progress in society or have the possibility to learn their own language will not be a privilege vis-a-vis other members of the society. It is essential, however, that such measures do not go beyond what is reasonable under the circumstances and are proportional to the aim sought to be realized. Article 8.4 serves as a reminder that nothing in the declaration can be construed as permitting any activity which is contrary to the purposes of the Charter. The commentary remarks that, as pointed out above, the rights of the minorities are different from the rights of the people to self-determination, and minority rights cannot serve as a basis for claims of secession or dismemberment of a state. Explanation of Article 9. Article 9 is about role of the specialized agencies and other organizations of the United Nations systems with respect to the rights of the minorities. The commentary remarks that wherever possible, the agencies and bodies of the United Nations system shall contribute to the full realization of the declaration. The Working Group on Minorities, established by the United Nations in July 1995, served as a stimulus for such cooperation. This article should be seen in the light of the UN Charter, Articles 55 and 56, according to which the organization shall promote respect and observance for human rights and fundamental freedoms. Conclusion. The UN Declaration on Minorities, the most important minority document, represents a clear and important assertion of the legitimate role of the international community in regulating and monitoring state-minority relations. The long-standing view that the treatment of minorities is purely a domestic concern has been decisively repudiated, and this has given the concerns of minorities a new international legitimacy and visibility. However, the existing standards are often too weak in both their content and monitoring to achieve their intended goals of reducing ethnic violence and secessionist mobilization. Thus, what remains to be done is that the declaration needs to be converted to a binding treaty. Implementation mechanism also needs to be reformed. Thank you.